Great. So, hey Nick, how are you doing?
Good and you, Bruno.
Good, good. All right. So, jumping straight into it, there's two questions for you. They're both leasing questions. They're both agent related, but I mean, this applies just as much to landlords as it would to agents. So, the first question that we have relates to furnished units, and we get this a lot, all the time. And it relates to the condition of the actual furniture in the unit and whether it's suitable, because now a person is in theory paying rent in order to have this furniture in the unit. And a lot of tenants, and in these circumstances, tenants have complained about the condition of a particular piece of very, very, very expensive furniture and is demanding that the furniture be replaced, failing which they want to withhold rent. So, Nick, from your experience, what would you suggest the agent slash landlord does here?
Perfect. So, as you say, we do get this a lot. This is another one of those elements in a leasing, a leasing situation that can be very contentious. So the first thing is that I want to mention is obviously how do we avoid something like this happening? I'll deal with the consequences of it happening, but the first thing I want to deal with is avoiding. And obviously, as you say, this came from an agent, but for landlords as well. If you're going to engage in leases where there are furnished units, okay, you're going to be leasing out the movable assets. And so the best way to avoid something like this is ensuring that just like you would do with your immovable property, the tenant has sight of the property and goes through and there's a defect list that's looked at. Okay. So you have obligations in terms of an immovable property, in terms of the Rental Housing Act, to do an inspection and to list out any defects. Okay. If you're going to lease a furnished unit. Although you don't have a legislative obligation to do this, it is smart in practice to do this as well. Make sure that anything that's being let by you to the tenant is also inspected, is also looked at, so that you can avoid these issues before the tenant even moves in. All right. It might be something that, furnished units generally, most furnished units are not, furnished with very cheap sort of stuff. Furnished units generally, in my experience, are units that have quite expensive, quite extravagant, furniture that is going to be leased with the particular unit. And so it's important that you take account of these things as well. Go through them, make mention of the condition that they're in if you can. And in particular, this helps the landlord at the end of the lease agreement, because you also don't want to do a furnished unit, get out at the end, and you find that all your stuff is damaged. In particular, where you have perhaps furniture that's of a particular value. It can be very, very costly at the end. So make sure that you do that. But look, in respect of this particular question, so we've already got a lease agreement. The tenant is in. They're saying that something needs to be replaced. And the actual question here is the tenant's threatening to withhold rental in the circumstances. Okay, so we don't actually have information about what happened with the inspection that would help us in the particular circumstances, but insofar as a tenant is allowed to withhold performance in terms of the agreement. Okay, remember, in terms of general contract law, you can't unilaterally change the terms of a particular agreement if you're not satisfied with a part of the agreement. Okay, so in general, tenants can't just decide unilaterally, I'm not going to pay you rent until something I want is addressed. That's not how the law works in general, and specifically in for a leasing circumstance. Please make sure you've got a lease agreement that is well drafted, that deals with a situation like this. So a simple clause that in your rental clause that deals with payment of rental, any a lease agreement worth its salt is going to say that there can be no deduction, withholding, or set off. Okay, so that will specifically deal with the issue of the tenant, to say you can't actually unilaterally decide that you're withholding. From the tenant's perspective, they wouldn't be able to do this in any event in law. If you are of the view that the couch is not what was advertised at the point that you entered into the lease agreement, it's a breach of lease agreement. And like any other breach of the lease agreement, you would have to follow a process of putting the landlord in breach and then electing a specific remedy in the circumstances. You simply cannot just withhold rental or performance in terms of the agreement.